you will end up paying money for the assets in the trust, and the income in the trust is going to be taxed at a higher tax rate. So I'm not saying don't do trust, but you've got to be extremely careful. Some people want it, the asset to stay in the bloodline. So if for the sake of argument you have got £10 million, you think, well, if I give it to my son or daughter, if they have a bad marriage, then the other party to that marriage may disappear with half of it. If you have it in a trust, it follows the bloodline, and then there isn't the risk that would happen. So there's pros and cons to it, but you've got to be careful that the cons don't outweigh the pros. And it can get expensive if you do it wrong.
Okay, so I'm going to cover fix, if that's all right, James, and then I'll throw it open to questions. So we're just kind of, yeah, I mean, definitely you're going to get a chance to ask questions, but so let's talk about fix. So okay. Nigel yesterday spoke and he mentioned about how with the proceeds from his company sale, he's significantly benefited from a FIC, which is a family investment company. So talk to us about FIC. What are FICs?
So let's go back to my £10 million. I got £10 million and I just spoke to my accountant and he said, well, if you put that in a trust, the chances are you're going to get hit by tax. I say, okay, well, what else can I do? So a family investment company is, say, where I want to get it out of my estate. I don't want this £10 million because I know I'm going to get clobbered here. I want to get it out, but I want some control over it because the kids aren't old enough or not experienced enough in my line of business. And say, I don't know, I'm a shoe manufacturer or something, and so I fancy setting something else up like that. So what I'm going to do is put £10 million in a brand new company, of which £200,000 will be voting shares, which I will have, and £9.8 million will be non-voting shares. And once I've set up this company, I'm going to gift the £9.8 million of non-voting shares direct to the kids. And you've got to do it immediately before there's any capital gain in the company. So if I did
so you do that at formation, basically, of the company.
Yeah, you set up the company with the shareholdings, and then once you've set it up, you transfer the shares to the kids.
And this is just to be clear, even though it's how you're doing it is what makes it a FIC. It's just literally a limited company.
Yeah,
yeah,
it's a limited company.
Okay.
But the idea is that I've transferred non-voting shares. So I've got 200,000 shares. The kids have £9.8 million of non-voting shares. So basically, I still control the company. But from a capital point of view, an inheritance tax point of view, I've given away £9.8 million. Now, as long as I live 7 years, then that exercise will be totally free from inheritance tax, and it won't hit the trust tax charge, which could be 20% by giving by lifetime inheritance tax rates. And then what could happen is I could build up that company, but by building it up, the accretion of wealth will be allocated to the kids, not me, but I'm actually running it. Now, you could do it different ways. You could say, look, I've only got 10, say only, if I've got £10 million, you might say, well, tell you what I'll do is I'll do the share bit with 5 million and I will lend it 5 million so the company can then gear up on that money. And then I can draw down on the 5 million, I'll take it back, which you can do with a loan, but you can't do very easily with shares without added complications. And you can mix and match. So you can have part debt, part loan capital, different shareholdings, things like that. So in this structure, what I may consider is Rob and Gwen would give shares perhaps to grandchildren rather than direct to children. Because if you gave them to grandchildren, then grandchildren can benefit from dividends and they get a personal allowance, the same as you are and I do, at £12,570 if you don't earn more than £125,140.
Some people are going to ask a question, Chris, just to interject there. They're going, age of grandchildren for being shareholders.
It doesn't matter. I mean, what you've got to bear in mind is that any gift from parent to child, if they are minor, is any income deriving from that is taxed on the parent. So you want the gift to be from grandparent to grandchild, not from parent to grandchild. And then you could say, well, if the grandchild has dividends, say, of £12,570 a year, the grandchild can, through a bare trust, can put that towards, I don't know, school fees or costs of the child. But you can use their personal allowance. So if I had a minor child and I was a 45% taxpayer, basically I've got to earn £25,000, be taxed at nearly 50% to give them £12,500, to give them half the figure. Whereas in this case, they could get it in their own right. So with a FIC, then the child could have dividends as well.
So
but you've got to be careful how you structure that to make sure it's not taxed on the parent. But what you're actually doing that is for an inheritance tax angle and capital gains tax angle, not for income tax. But then you've got to think about the income tax angle.
So does this work, Chris? So I mean, give an example from not this room, but from our community. So client, trading business, has children, doesn't have grandchildren yet. Trading business makes a lot of money. He set up a FIC. Now it's him, his wife, his children, shareholders. I don't know what the shareholding is, so I'm not going to make that piece up. The trading company lent a big chunk of money, millions, into the FIC that then went and bought a load of property. Rented out, rental income. So the company's making money and obviously paying its taxes, etc. But there's value accretion because he bought sensibly, because he bought with cash largely, he got discounts, etc. So there's equity in those properties. His intent is over time is that the FIC is going to repay the loan, and therefore the value is the fact that he's got a property portfolio which has rental income, and at the end of the day, I don't know the mechanics of how they're planning on doing it or what the shareholding is, that the children who are currently minor are going to benefit from shareholding in this company. And they were shareholders when it was worth nothing because he didn't even own any property, and now it's got many properties in there. Is that an example that works or not?
No, it's an example that works. You just got to be slightly careful that you don't do the Dave Gilmore example. I don't know if anyone's seen the Dave Gilmore article. So Dave Gilmore, very successful band player with Pink Floyd, his limited company bought the house he lived in. And what actually happened is that they then decided they didn't need the company anymore, and they forgot that it owned his house. And it was struck off, and it's now owned by the Duchy of Lancaster. Now, you don't want a limited company owning the house you live in, because A, you can't claim principal private residence relief, which means the capital gains is free. And B, you'll be subject to ATED, annual tax and envelope dwelling, because you live in a house owned by a non-natural person. And you're not going to get all the benefits that you'd get otherwise. So for those reasons, your example is fine as long as you don't, and none of you live in any of those houses.
Yeah, that's the case, I believe. Yeah, very good, very good. So good. I think that we've spoken about some of the rules around inheritance tax and the changes in the budget. We've spoken a little bit about kind of conceptually about trusts, and we've spoken a little bit about FICs. There's probably going to be 1,000 questions. We can go as tactical as you want, and some of you just may have questions that are around, well, how do you find somebody, or what do you look for? But I'm going to hand it over to you guys. I'm going to come round with my mic so we just get it for the recording, so I'll stand by you when you ask your questions, or if you ask it too quickly, I'll repeat it into the mic for the members that can't be here. So over to you guys. Well, first of all...
So can I just say a couple of things?
Oh, yeah, you can.
One, when I have meetings with clients, I normally say, as long as you just walk out this meeting with knowing the bones of what I'm talking about, you don't have to know how the flesh works. But as long as you understand the interrelationship between capital gains tax, inheritance tax, income tax, you then need to speak to someone who does to make sure you can drill down on it. But if you don't know what questions to ask them, you're not going to progress it. But basically, we just got to understand that given what's happened with the budget, if you've got a lot of assets, it's now going to be a problem. We need to sort our wills out, capital gains tax, inheritance tax, and then move the conversation forward. And you just want to make sure the person you're talking to has got the ability to answer all those questions.
Oh yeah, and my closing thought would be just to say, it stuns me, Chris. I mean, I bet this won't surprise you in the least, but it stuns me how many entrepreneurs that I'll speak to, and they may be young, i.e. not in any danger of dying soon, but they have no wills. They've got children, but no wills. And I'm not going to ask, but if you're in this room and you've got children, you've got no wills, shame on you. Like, you really need to get that stuff accidents happen all the time. People sadly die, tragic and die young, and you're leaving your spouse and children to deal with a mess. So regardless of the very painful tax consequences, if anybody's ever had the joy of having to deal with intestacy laws, it's ridiculous. So get your will, revise your will regularly, and you may not be as extreme as me. I mean, I preach to my children who are currently aged 15, 13, and 10 about the contents of the will and how it's structured. Because who knows if there was an accident, I kind of go, I want them to be able to speak up if whoever's the executor of the will, the executors I have, who I trust immensely, I kind of go, well, I want the children to be able to speak up if they disagree. I don't want them fighting over it after I've gone. I don't want anybody to have any surprise about when they're dealing with the tragic grief from my passing, Chris. They'll be devastated, right? I don't want any surprises. You're just asking for a train wreck. Get your will sorted. So with that said, are we good for those questions?
Sorry, just another thing is make sure you got the right executors. I spoke to a client and I said, have you sorted your will out? Yeah, it's all sorted. I said, who's the executors? Oh, my wife's dad and my dad. I said, wait a minute, but they're going to die before you if in the normal order, so that doesn't make sense. I mean, you want to make sure that the people looking after the wills are the ones that are young enough to survive all this.
Yeah, definitely. Very good. All right, let's go for questions. Just mark a new track.